we still had the Supreme Court decision. The other thing that happened was very shortly after that decision, the Abu Ghraib pictures came out, and that scandal broke. We were all appalled and shocked, I think, at the way that the images that came out. But what happened? What did Congress do? Well, Congress kind of did two things. The first thing that they did was they reacted to the to the Abu Ghraib photos, and they passed something called the Military Detainee Act. I'm sorry, the Detainee Treatment Act, the DTA, 2005. And a big part of that act really focused on how the military was supposed to treat people in military custody, addressing the issues in Abu Ghraib, which was good, which was very good. John McCain was the key pusher on that. But why would the Center for Constitutional Rights oppose the Detainee Treatment Act? Because that seems like a no-brainer. Well, the reason why is because further down in the act, the devil's always in the detail, in the fine print, it said, oh, and by the way, the federal laws of habeas corpus, now congressionally, we're going to change the law so they specifically do not apply to the men in Guantanamo, right? Supreme Court says we interpret the law as applying to the men in Guantanamo because Congress has not said that it doesn't. Congress says, okay, now we're saying that it doesn't. So we are now back to the drawing board. We were able to get into federal court to file habeas corpus petitions. They began to stack up. We kept filing them anyway. The courts have not decided any habeas corpus petitions at all. All right, so what happened next? 2006, we're back in the Supreme Court. Why are we back in the Supreme Court? Because part of what the Bush administration did was, in addition to the CSRT proceedings, which I talked about, they also came up with the idea of military commissions. Now, we had been saying, CCR had been saying for years, look, either you try these guys or you release them. You can't hold them forever. So they came up with a trial-like system to try some of the men. And George Bush did it on his own. The military came up with it. They wrote it up. Again, that it's something that involves no civilian courts whatsoever. You do have access to civilian lawyers, but it was a system that existed outside of the federal realm of the U.S. law. So there was a man named Salim Hamdan who was supposed to be what's the name of Osama bin Laden's driver. And he was one of the people that was in Guantanamo. And so they're trying to charge him by military commission. He goes into federal court, to Supreme Court, and says, wait a minute. This military commission system is inconsistent with what the court said in Rasul. The court in Rasul said you get to go to federal court, and now they're trying to carve out all these little molehills and hoops for us to jump through. The Supreme Court looked at that, and they said, you're absolutely right. They said that Congress didn't authorize this military commissions, so they're invalid. So President Bush, you can't try these guys by military commissions. And very important to human rights scholars here, the Bush administration had been taking, let me take one quick step back. You may or may not have heard about the secret torture memos. I know, there's a lot of stuff. Secret torture memos. Raise your hand. Secret torture memos, anybody? The Office of Legal Counsel, part of the Department of Justice, underneath the Attorney General's office, there's a guy named John Yoo, and he was writing memos. And he was writing memos about whether the U.S. could legally torture people or not. Why was he writing this? Because remember I told you about the CIA black sites? The CIA guys were getting a little freaked out because Donald Rumsfeld is saying to them, and this is documented, and there's a book coming out by Philippe Sands, and there's a whole lot of stuff. Donald Rumsfeld is saying, you gotta push these guys. We need information. There's a lot of pressure to get information. They were being pushed to torture. They said, look, we need a legal memo to tell us where the line is drawn. So they start writing this legal memo. The legal memo comes out and says, essentially says that the U.S. government is allowed to do acts that would normally, under international law, constitute torture. But the way that we are interpreting international law, because of course it's up to the individual states, individual countries to interpret international law through federal statutes, we're determining that things like beating people, like keeping them in the extreme cold, like isolating them for 56 days, by having the lights on for 24 days, and even by waterboarding people, is not torture under the way that we conceptualize torture. Now, why is that important? That's important for the following reason, because going back to 2006, in the Hamdan case, the Center for Constitutional Rights argued that Common Article 3 of the Geneva Conventions applied to the men in Guantanamo. Now, why is that important? That's important because the Bush administration has been saying, even though this is a war on terror, these are not prisoners of war. And since they're not prisoners of war, we don't have to treat them the way that we would treat normal prisoners, AKA, we would not have to treat them the way that we would expect them to treat us if we were captured, right? So when we went to the Supreme Court and we said that Article 3 of the Geneva Conventions does apply to habeas corpus, to the detainees, the Supreme Court says you're right. It absolutely does apply to the detainees, which means that you can't treat them the way that the Bush administration had been treating them, including things like not allowing the International Committee of the Red Cross to go in and talk to these guys. Now, this is where we get to the interesting piece, which is, why is Donald Rumsfeld a war criminal? The Center for Constitutional Rights in 2006 went to Germany, filed a lawsuit under the universal jurisdiction laws. It's a lot of law stuff, but it basically comes out of the Nuremberg principles and the idea that a torturer anywhere in the world needs to be brought to justice, even if in that country people refuse to bring him or her to justice. So if you think about Augusto Pinochet, who was tried and convicted in Spain, that was an example of universal jurisdiction. So we took the position that Donald Rumsfeld was a war criminal. We went to Germany and we asked the German prosecutor, who has jurisdiction over these issues, to prosecute Donald Rumsfeld and the higher-ups for their program of torture that they used at Guantanamo and in the CIA black sites. And we did that not because we were making it up, but because Newsweek had come out with a torture log that detailed Donald Rumsfeld's approval of all of the torture techniques in Guantanamo, and that the men in Guantanamo, the leaders in Guantanamo, went to Abu Ghraib, and they taught the torture techniques to the people in Abu Ghraib, and we know that the torture techniques were used in the black sites. But when we filed the lawsuit, again, with the hate mail, right? How can you call the Secretary of Defense a war criminal? And it's very easy. Here's how you call the Secretary of Defense a war criminal. When you take the position that the Geneva Conventions does not apply, and you torture people, and it turns out that Geneva Conventions actually do apply, your torturing of people makes you a war criminal. This is the basis of it. If you don't comply with the Geneva Conventions and you torture people, you are a war criminal. Well, taking us back to I'm going to wrap up so we can have some time for questions. But taking us back to Guantanamo, the question then became, what do we do now? Because we've just won this victory with the military commissions, right? The military commissions are struck down, and we now know that the Geneva Conventions apply. We know that Donald Rumsfeld's very high ups. There's a recent article about Condoleezza Rice and everybody else knowing about this authorized torture. These cats are all war criminals, right? What does Congress do? Congress comes in, 2006, passes the Military Commissions Act. Look it up, Military Commissions Act. It is one of the really most devastating pieces of anti-civil liberties legislation. And the things that it does are too long to mention, but I will mention two things. One is that you remember that the Supreme Court said this law of habeas corpus applies. Congress said now we're changing the law so that it doesn't apply. What the Military Commissions Act did was they basically did something that's called jurisdiction stripping. They said even if it did apply, this law, Military Commissions Act, says federal courts are not allowed to even look at habeas corpus petitions from detainees in Guantanamo. Now, why would they do that? Well, the reason why they would do that, because they knew that the next challenge that was going to come was not a statutory challenge to habeas corpus, but a constitutional one, right? Going back to the beginning, from the beginning of the Constitution, the Congress shall not abridge the right to habeas corpus unless it's a time of insurrection or rebellion. Everybody agrees that this is not a time of insurrection. Everybody agrees this is not a time of rebellion. So the question is, did Congress, in passing this Military Commissions Act, and not allowing courts to even hear habeas corpus from these group of people, did they suspend habeas corpus? Other thing that the Military Commissions Act did was that it provided immunity for all military personnel that dealt with people in the black sites and people in Guantanamo and people in Abu Ghraib going back to 1997. What is immunity? Immunity means you can't sue them, right? They have 778 pissed off people that have been, a large number of them have been tortured, and they passed a law that said, even though the Supreme Court says you guys are war criminals, we're not going to allow